first thing is I think it's about time for them to consider the request for the certificate of appealability. That request was filed, if I remember correctly, somewhere in the vicinity of about July 3rd. And so they're well over a month behind schedule. Normally something like that should have been considered way back early in July. The certificate of appealability is the very first thing that they consider with respect to an appeal. And the only reason that the Ninth Circuit has to consider it is because of the fact that the district court refused to issue a certificate of appealability, even though we have numerous constitutional issues in the case, and even though no one opposed my writ of habeas corpus at the district court level.
Is it unusual for the district court to refuse or deny a certificate of appealability? That sounds so ominous that they would be denying you your right to appeal.
Oh, it's highly unusual. I mean, it's basically not only unusual, it's outrageous. And then particularly in this case, where neither the sheriff didn't even answer the writ of habeas corpus and thereby broke the law. And in addition to that, the Superior Court didn't oppose any of the grounds in the petition for writ of habeas corpus, and also didn't certify why I'm in jail. So the action of the district court is just totally and completely outrageous.
Will you explain to us, when Judge Walters denied the certificate of appealability, he also made the notation, with prejudice. What does that mean?
Well, that means that call may be monitored or recorded. That basically means that we can't refile the writ of habeas corpus in his court, and we can't really ask him to reconsider. So it meant that the case automatically goes right up to the Ninth Circuit. The way that the procedure works in the district court is that the minute that we file a notice of appeal, the case is up into the Ninth Circuit, and the district court has to either grant or deny a certificate of appealability. If the district court grants the certificate of appealability, there is no question that the appeal goes forward in the Ninth Circuit. If the district court denies the certificate of appealability and denying, with prejudice, that means that automatically the Ninth Circuit considers the certificate of appealability. And what Judge Walter did is he denied the certificate of appealability, and he checked the box saying that there was no constitutional right that was impaired, which is totally and completely beyond belief, given the fact that there are about a number. There's the First Amendment, there's the Fifth Amendment, and the 14th Amendment constitutional rights that were violated in this case. So, I mean, but we know from looking at what Judge Walter did, we know that he never even read the petition for writ of habeas corpus. So his denial of the certificate of appealability is consistent with everything that he did in this case.
Wow. Well, I guess the next step then is to wait for Monday to see what happens with the two-judge panel in San Francisco, and then go from there.
That's correct, and hopefully I would expect that they would grant the certificate of appealability, and then God willing, they would immediately take up the motion to be released, and maybe even be correct enough to go forward and just overturn the case right then and there. Because given this particular case, this is such an unusual case that it's very seldom that you find a writ of habeas corpus where there's no opposition.
And I would like, for our viewers' sake, for you to explain why this is an emergency motion on your part.
Well, it's an emergency motion on my part for a number of reasons. The first reason being that with no opposition to the writ, have the physical emergency that is taking place, and that since I've been in jail, I have contracted a staph infection, I contracted back pains, and I have swelling of my legs, my feet, and my ankles. So we've got the entire physical things that have happened that is due to having been in jail. And the third thing that we have happening is we have the financial problems that are taking place, which is the loss of the house, which can be coming up because of the fact that having been in jail, I've been denied my Fifth and 14th Amendment rights to earn a living, and actually, and through that, we have the situation of possibly losing the house. So unless I get out of jail and can get out there and start earning some money, we're suffering I'm suffering physical hardship and suffering financial hardship.
How is your family?
And I'm now going into the 6th month of being unlawfully incarcerated.
How is your family taking all this?
Well, needless to say, my family are not happy campers about this. But, there's one thing that I can say about my family, and that is that nothing is going to break our family. When this judge has thought that he's going to try and coerce me into telling him about my assets so that he can go on with his unlawful activity, and he figured that he was going to break me and my family, that is not going to happen. Nothing will break our family unit. We will end up prevailing, and justice will prevail, and 38 million Californians are going to get their judicial system back before we will give in to this particular judge or to any of the judges who received immunity for their criminal actions. We're going to get our judicial system